Good afternoon, everyone. I hope everyone is doing safe and well. My name is Archita Sarkar, and I'm a lawyer and company secretary with Rödl Partner. And I've been working with Rödl Partner for the past 5.5 years. As per the Rödl Partner invitation that you may have received today, we are conducting a digital high tea series, which is a 1-hour technical knowledge sharing session that we're conducting once a month till the end of this year. The session usually covers topics which are considered to be common questions for those companies with foreign direct investment, FDI, and who are recently set up or looking to set up in India. Today's topic is Key Managerial Personnel, KMP, Liabilities and Compliance Management. We would be briefly touching upon who KMPs are, with emphasis on directors, and how a compliance management system provides a mechanism to reduce such liabilities on the company and on their KMP. Our focus is on directors in private limited companies who are recently set up in India. So first, I think we're going to start with a short introduction to Rödl Partner, and then we can move on directly into the presentation. We will have a Q&A session later on at the end of the presentation, but you can already begin asking your questions on the topic in the chat box, which is presented to you on your right. I would be putting off my video now in order to preserve the bandwidth and the speed of this webinar, but I'll put it back on later on during the Q&A. Okay, let's start. All right, so Rödl Partner has been founded in 1977 as a single practice in Nuremberg. And worldwide, we have over 5,000 colleagues in 49 countries with 109 wholly owned offices. We are your one-stop shop when it comes to legal, tax declarations, business process outsourcing, accounting, tax compliances, and we even provide audit services with our cooperation audit partners. In India, we were established in 1997, and Rödl Partner focuses on basically the growing Indian market, and then we established Rödl Partner India Private Limited in Delhi in 2007. In 2008, we opened our offices in Mumbai. In 2012, we ultimately opened our Pune branch office, but as we saw the growth in German invested companies doing so well in Pune, it quickly became our largest office, and it resulted in Rödl Partner Consulting Private Limited. We also have our offices in Bangalore, Chennai, and Ahmedabad, which are working points. We advise more than 450 multinational companies. Our services are provided by professionals who are lawyers or chartered accountants. There are more than 150 of us, and we have our integrated cooperation partners as well. And we are located as I said, all over India, and are supported by our India desk in Nuremberg. You can see our offices internationally and on the world map. These are our offices only in Europe, but excludes Germany. And as you can see in Germany, since we are committed to German Mittelstand companies, these are our offices all over Germany. All right. Now we will begin with the presentation on KMP. Today's topic is going to touch upon all of these sectors as much as I can, but as we all know that these topics are very technical, and there's a lot of information when it comes to this. So any information or any questions that you may have, which I may not be able to answer today due to time constraints, you can still send it to us, And I would be happy to provide the answers to this later on via email. You will also get a copy of this presentation, so you don't need to worry about that either. Okay. Key managerial personnel. Now, in India, the function of a company is governed by the Companies Act 2013 and the rules that are made thereunder. A company which is a legal entity is considered an artificial person, and the persons who are in charge of running the affairs of a company and maintaining these operations of the company are the directors and the other key managerial personnel, or KMP, of the company. Now, under the Companies Act, KMP have been provided to be the Chief Executive Officer, CEO, or the Managing Director, MD, or Manager. They are also called as the Company Secretary, the Whole-Time Director, and the Chief Financial Officer. So under the Companies Act, only these particular designations are considered as KMP, along with the directors. Now, every listed company on the stock exchange and every other public company having a paid up share capital of, say, INR 10 crores or more is mandated to appoint the KMP, which are other than the directors. So unless you are a listed company, most of these provisions will not apply to you. But as a private limited company, you may appoint managing directors, managers, CEOs as well. And there would be certain provisions which would not be as stringent on a private limited company. A private limited company, however, does have to appoint a whole-time company secretary the minute it crosses a paid up share capital of rupees 10 crore or more. This is something that we frequently get since it's a private limited company. Many of our companies have forgotten to appoint CS at the time when the share capital requirement was only 5 crores. And later on, with the introduction of the INC 22A form, where it was required that the company completes all its compliances before it can go forward, what happened was that since a lot of companies were required to appoint a CS but had not appointed a CS, they became default on this compliance, and they weren't able to file any other compliances until such time as they appointed a CS on their payroll. Okay. The provisions that are related to KMP, what we have to remember over here is actually there are several provisions, and we won't be able to touch upon everything, but I will try to give a gist of what are the important things that we have to consider, especially when you are a company that is setting up or you're looking to hire KMP directors and you're providing them with a certain designation. So KMPs, like managing directors, whole-time directors, or managers, have to be appointed with a term of 5 years. They can be reappointed in their last year or their last tenure for a further period of 5 years. In case of KMPs like CEOs, CFOs, or CSs, there's no actual fixed tenure of how long that they can be appointed for. Appointment of KMPs require board approvals, and generally, when it comes to listed companies, etc., they also have to be, regularized in the annual general meetings. In case a KMP resigns, that is, if your MD or your manager or your whole-time director resigns, the vacancy should be filled within a period of 6 months. If you have KMPs like CEOs, CFOs, then you also might have, you're a big enough company to also have a nomination and remuneration committee. And this recommends a policy to the board for the remuneration of the KMP. The remuneration of the KMP is a big subject matter because here we are talking about key managerial personnel having a significant, interest in the company. So this is also regulated by separate provisions altogether. KMPs are required, just like directors, to disclose their concerns or interests in other associations. Any relative of a KMP will also be considered as a related party under the Companies Act. Any nature or concern or interest of the KMP on proposed matters have to be disclosed to the board in the notice of such meetings. And if they are not doing something like this, then they can be personally liable for any of the undue benefits that are provided to them due to this non-disclosure. They are additionally also prohibited from insider trading, forward dealing in securities. They have to provide their register of their shareholdings in holding subsidiary or associate companies. They have several other kinds of restrictions as well as provisions which relate to how they operate within the company. And for example, like I said, that the financial or other interests, they have to disclose such an interest, because if they have say 2% shares in another company, and this disclosure of shareholding has to be made. And if this non-disclosure has somehow resulted into undue gain or advantage, then they could be punishable by up to INR 50,000 to almost 5 lakhs of their personal liability from their pocket. When we say that KMPs have contractual duties, these are duties that are imposed of them from their direct employment agreement with the company. But they also have significant other duties which are coming directly from the Companies Act, which is where they have fiduciary duties as they are acting on behalf of the company, and they are considered as officers in default if they have consented to or had knowledge of certain defaults of the company, and it's proven that they were not working in the best interest of the company. What I would like to point out over here is that KMPs are also required to sign on various very important documents, including the financial statements of the company. So the financial statements are usually required to be signed by the chairperson of the company or by 2 directors, or if one of them is a managing director, then the managing director has to sign along with another director. If you have a company secretary who is on whole-time employment with you, then the company secretary also has to sign on the financial statements. Sometimes the question that we usually get with KMPs is, since their remuneration is so important, whether this disclosure is also publicly available. And the thing is that when you file an annual return with the MCA, that is the Ministry of Corporate Affairs, every year, then the remuneration of managing directors, full-time directors, these are available on the annual return. And anybody who can log in and download such annual returns do find out the remuneration of these directors or these KMP. Okay, to the next point, where we are shifting now from KMP directly to directors, which is really our focus, since most of the companies that we deal with have foreign direct investment. Abroad, when you appoint a director or a managing director, this distinction may not be very defined. In India, there are several different types of directors, and each of these directors have certain meanings behind the names that are and the designations that are given to them. It also has a certain bearing towards what kind of liabilities are imposed on them. So what we're going to talk about are the different kinds of directors, the different types of terminologies which are used, probably which you have heard from your company secretary or from your Indian director when they say that, well, I'm a resident director, we need to appoint an alternate director. And for somebody who is abroad and who's setting up in India, these terms are not really different from each other. For them, it is a director is to somebody who is managing the affairs and is responsible to the shareholders, which is very true. but we also have other points, other finer points within this within these definitions. So the first point is resident director. As you know, now it's mandatory that in India, if you are setting up a company, or if you have a company in India, then you have to have a resident director. A resident director is somebody who has been living in India for the last 182 days in the previous calendar year. These directors will have a PAN in their name, possibly even an Aadhaar card in their name, and this information is is required because you'll need the PAN and the Aadhaar card and these kind of details when you file other forms under the income tax or under the MCA, etc. So it gets directly linked with all of these forms. So the information is that you have a resident director on board is crucial. The next, you have first directors. First directors are those who have been named as such in the Articles of Association when you are incorporating the company. They may be retained as directors for the rest of their term, or in the first annual general meeting, or otherwise they can resign before the AGM as well. Alternate directors are directors who are appointed as the name suggests, only as a proxy for a director who cannot be attending certain meetings. This is usually only for a period of up to 3 months between the board meetings, and they are allowed to sign on behalf of these directors so that they are able to do such things as the original director would have if they were in his or her office. As soon as the original director attends the meeting, however, the alternate director ceases to have any kind of powers and must vacate the office immediately. Other than that, we have whole-time directors. These are KMPs. These are directors who are in full-time employment and draw a salary from the company. Managing directors. Managing directors are actually the directors who have significant, powers and are entrusted with substantial powers of management on the affairs of the company. An MD in India has substantial authority for signing documents under different laws and different returns with a lot of different regulatory authorities. He also draws a salary from the company. He may be given percentage of profits from the company, and if he is being given certain profits from percentages of profits from the company, then there are certain regulations with it. Private limited companies are luckily not under this purview and have certain benefits that these provisions do not apply to them. But as a result, managing directors really have separate provisions all to themselves, and there are several cases and case laws on what a managing director can do even without the power of a board resolution. We have directors who are appointed in casual vacancies. These are directors who are generally appointed and between 2 annual general meetings, and there is possibly a death or insolvency of that particular director, and his place has to be fulfilled on the board. Non-executive directors are directors who do not actually have any kind of salary which they are drawing from the company. They may or may not be in control of the operations of the company. Generally, they just monitor the activities of the company, and they are not ones who are actually involved in the day-to-day affairs of the company. Additional directors are directors who are appointed, between 2 annual general meetings, and they have to be regularized in the next general meeting by the shareholders. They are just new directors, and they will become, from additional director, they can become directors only after the shareholders have approved their appointment. Independent directors, these directors are actually only seen on listed companies, and there are several provisions based solely for independent directors. Since these directors are actually required to take certain exams, they have certain codes of conduct, appointment, reappointment, what their duties and liabilities are specifically mentioned only for these kind of directors. These kind of directors are only appointed in the larger listed companies where there are certain thresholds, which this is required mandatorily that they are appointed over there. And they also have certain kinds of provisions where they may not be entitled to any kind of stock options or sitting fees, but they might get, commissions and reimbursement of expenses. All of these directors can get sitting fees, but this is an additional provision, and it can come from your articles of association, or it can come between, a discussion between your management and your board and the director. Whole-time directors, managing directors, executive directors who are actually, involved in the day-to-day operations and draw salary may not get additional sitting fees, but the other directors who are not involved in the in the day-to-day affairs and are only, attending the meetings in order to fulfill a certain criteria may get certain sitting fees. This depends. Okay. Next part, duties and liabilities of KMP and directors. Mostly we will be talking about the directors here. The director's duties are largely derived from the law of trust and agency, and it imposes both fiduciary duties and duties of skill, care, diligence on the directors, because they are liable for being in any kind of breach in complying with their duties. Accordingly, the directors that are trustees of the company, they are also trustees of the money and the property, and they act as agents who are entering into transactions on behalf of the company. So the Companies Act has imposed certain duties and have termed these directors as officers in default to put certain liabilities on them. Directors of listed companies are also, of course, required to comply with other provisions under the Securities Exchange Board of India. So this extends more than just the Companies Act. When you're a director in a company, you also have an additional effect where you are exposed to certain liabilities under different legislations. So labor laws, environmental laws, all of these become your duties and your liabilities for non-compliances by a company. So this is typically because all the charge of the business is with these directors who are responsible for the day-to-day affairs, who are given high powers to be able to sign contracts and to be able to enter into various transactions. All right, so if you can see over here, we have statutory duties and we have contractual duties. Contractual duties would be duties that you might have directly from your employment agreement. And it talks about your roles, it talks about your responsibilities and the kind of powers that are given to you. So the powers might be on what limit you can enter into transactions before you need a board resolution, or it might be about how many people you can hire up to a certain level or a certain salary threshold before you need board approval. And it might even talk about the kind of different points like your revenues and how much is expected that you provide, or the kinds of terms and powers that are given to you in for the business and the commercial understanding of that. It might be different from the powers that are given to you under the Companies Act. So under the Companies Act, where you may have several powers and nothing might be defined in terms of what limit or what threshold that you can sign a certain contract, you might be limited by your employment agreement. Other than this, you have statutory duties, which if you can read on the screen itself, it talks about the articles of association of the company and what the objects of the company are. So your basic duties would fall from what this company has to do and what is within the scope of what is allowed and not allowed under the charter documents of this company, and which is, basically for the benefit of its members and what's in the best interest of the company. You have to obviously discharge your duties with reasonable skill, due diligence, and not have a situation where you will have possible direct or indirect interests, and that may conflict with the interests of the company. Having undue gain or advantages, either to yourself or your relatives or your partners or associates, these lead to direct contraventions in your duty, and it might be that you have high liabilities to pay whenever there is such an undue gain provided to you that has been missed out by the company. So of course, the duties are which are imposed both under the Companies Act, under your employment agreements, is the way to look forward at how and where the liabilities will be imposed on you. Obviously, those are the main criteria, and when you have a case against you for any kind of contravention where you're saying that the director has defaulted in his duties towards the company, these duties would be seen, and if it is proven that you have actually taken certain steps knowingly with malified intent to go against your responsibilities towards the company, you may be charged with the penal provisions. Now, of course, under the Companies Act, there are several provisions which have several liabilities, and all of these liabilities have both criminal as well as monetary aspects to them. According to the amendments under the Companies Act, however, then what happened was that where there were severe criminal liabilities, these have been removed because there are certain things where they have come to the understanding that just for procedural default in compliances, a director shouldn't be held criminally responsible. But this does not mean that there are not hefty penalties that are coming from a monetary perspective. So when you talk about a director who has to, he has to act within the parameters of the MOA and the AOA, these are the charter documents. He has to, act within the parameters of the limits which are there in the board resolution and in his employment agreement. And if there are any contraventions here, he might be personally liable, where the fines may be imposed between 1 lakh to increases up to 5 lakhs. They are seen as agents of the company, so they may be personally liable only when they are acting to the default or have knowingly failed to take active steps. I know this is, when you hear about this, the first idea that comes for directors is that, well, it sounds like we are going to be responsible for every little thing. Under the Companies Act, no, and under all the legislations, of course, there is that provision which says that if you were not involved in anyhow, you have done your due diligence and you have tried your level best, obviously, you cannot be held liable for it. But practically, what we've seen is that when there is a default and a third party wants to instigate a default, and they want you to pay for it, or they want the hassle of tying you up in litigative matters, then they will, use any of these penalty and these provisions and lodge a case. And since there are several, it's important to understand that any of these compliances, which may not actually result into, say, an actual penalty being imposed on you, because you can prove that this was done with as much diligence as possible, it doesn't mean that you might not end up having the hassle of fighting your way through this case. And that's because since there is such a high liability, whoever is in the courts and the police, when it's a criminal liability, etc., are required that are required to really go through the entire process and to call the director several times and ensure that they have actually done everything in their capability before they say that there was no actual default by the director and he cannot be held liable. Officers in default are those officers who have given their consent in writing to such specifications, and this has caused a default. And it could be CEOs, it could be CFOs, it could be the managing director. It really depends on who these officers were and whether they were entrusted to a certain specification of their business and whether this part of this business has resulted in a certain a default. So for example, if your chief financial officer would probably be responsible for certain for your financial statements, and your company secretary would be responsible for filing the annual returns on time and holding the AGM on time. And it may not be that you are directly responsible as a executive director or a whole-time director, because there is another person who has been designated particularly for this purpose. But if you knew that there was a default and you know that there is a default that is happening and you've been in the company for a really long time and you know that this is going to happen and you allow it and you sign certain documents and you look the other way basically and you don't provide your dissent, or you don't really raise the subject at the next board meeting and you say that we are going to default on these parts in these compliances. If this is not recorded, then you can also be considered as an officer in default. And when there are certain proceedings against the CFO or the CS in this case, you would also be held as an officer in default because you did not object to the same, or you've taken but it's considered that you've given your consent to certain contraventions. In private limited companies, really, the truth is we probably don't have a CFO or a CS, which means that the managing director, the resident director, the non-executive directors are considered as the ones who are responsible for the day-to-day affairs. They're also responsible for all of these compliances, whether it falls within their scope or not, because they're the ones who have to sign the financial statements and attend the board meetings and complete all of these compliances under all the different laws. So, on the slide, we can see that the provisions talk about, penalties which go anywhere from 50,000 to 5 lakhs. Every provision has different kinds of penalties which are imposed on them, but the monetary penalties are quite high. So just to briefly talk about some of the provisions where we have these kind of 1 lakh to 5 lakhs, 10 lakhs to 50 lakhs kind of imposition of huge penalties. We have penalties for everything where you have failure in filing of the annual returns, or failure of registration of the charges that you may have created on the company's property, or the officer in default would also be imposed with the fines which result from 25,000 up to 1 lakh or 5 lakh. Violations which are relate to the significant beneficial owners of the company. Recently, there have been provisions related to SBOs and the forms which have to be filed by the SBOs. And if these kind of compliances are not done, then you can see on the screen that the fines which are imposed are quite substantial. We also have certain other provisions which relate to related party transactions and other kinds of transactions where the minors, what we consider as a minor procedural failing, may actually result in very extensive monetary fines. And sometimes these fines are not just on the company. it is, as we are discussing over here, directly imposed on the directors. We also have the main part of this where the Companies Act is coming from is frauds. And recently, the courts of law have been facing several cases related to commitments of fraud, which are committed by a director or KMP, and they're quite strict about the kind of imposition of both criminal as well as civil liabilities on them. For the purpose of, officer of a company or officers, when it comes to fraud, any act, omission, concealment of any fact, abuse of position committed by any person or any other person in any manner with an intent to deceive or gain advantage or to injure the interests of the company or its shareholders or its creditors or any other third party, whether there was a wrongful gain or loss, may result with imprisonment of not less than 6 months and may extend almost to 10 years, and a fine which may be up to 3 times of the amount involved in the fraud. Directors are also held personally responsible without any limitation of liability for all or any of the debts, where they have knowingly taken part to the fraudulent activities in this case. And usually they are not personally liable for any debt unless you can actually establish that there was fraud on their part. And the liability on any contracts that they may have entered into, again, unless there was fraud which can be established, is not really where the director can be held liable. What we have seen generally is in private limited companies, especially companies who are just setting up or have FDI, you would have one director abroad and you'd have one resident director in India. And what would happen is that because of the difficulty that is there in setting up bank accounts, or the additional signatories and the notarization and apostillization of the documentation that is involved with any foreign personnel who are being added to these bank accounts, we give the entirety of all the because we say that it's a small little company and there's not that much money involved, we give all of our powers to the resident director. And what we have seen, in the last couple of years especially, is that at this point, the resident director has substantial powers with the bank account and the checks and the signing of the checks. And when it comes and it's seen that perhaps the director hasn't been paying the GST or hasn't been, completing certain compliances or hasn't appointed the right consultants outside also to complete their compliances, or there are, gross errors in reporting or accounting or compliances, and you want to actually say to remove the director, what the first thing that happens is that you realize that, okay, I removed the director, I terminated his contract, and now I don't have a director on the board. I can't pass board resolutions. If I can't pass board resolutions, I can't change things in the bank account. If I can't change things in the bank account, it means that the person that I recently, asked to leave the company still has all the power when it comes to signing checks and taking out the money from the bank account. And interestingly enough, it's not easy to actually just tell the bank that we've terminated this contract, so you need to respect our decision as the shareholder and the director, and that you need to stop all payments from his side, and you need to add me as a director, as an authorized signatory as soon as possible. You'll be very surprised that something that seems so simple actually takes such a long time, that by this time, the director who was supposed to leave has taken out the money, has absconded, and there has even more of a loss that has taken place. And when you go to complain, of course, there are criminal liabilities and there's a civil litigation that you are trying to pursue on the terminated director for this kind of fraud that has taken place. But surprisingly, you know, what we've seen is that it's turned around and told, well, you should have had you know, another director on board. You should have had a 4I principal. How is it that he had the entire control of the board and the accounts and the documentation and the account and the employees of the company? So this is where we usually advise our clients also that, you know, it says have only 2 directors on board, but you know, make sure that you've said that just because it's the minimum number of directors, that you've also considered all the other aspects that come with it, that you have a 4I principle, that there is contingency plans in place when one director has to suddenly leave or resigns, or for, you know, any case there is a fraud in the company and you need to act fast. Okay, so other than this, there are, of course, several other liabilities that we were discussing under different acts as well. I have not mentioned every act out there, but some of them obviously fall under labor law compliances, they fall under environmental compliances, employee-centric compliances, and in India, obviously, the number of legislations are very, very large. And if you have to have somebody who is the person who is signing off on every kind of document, then it would probably be the resident director or the board of directors who are taking these kind of calls for the company. You know, under minimum wages, you can see that actually you have to maintain registers, and you can even be liable for imprisonment. Under the Factories Act, the resident director is actually considered as the occupier of the factory. And when you're the occupier of the factory, you have several other requirements which are needed under the Factories Act, which relate more towards the safety of your employees, of your contract workers in the factory. And if there was, you know, any kind of accident that takes place in the factory, then the resident director is actually liable for these kind of contraventions, or, you know, they would be the first person who is considered from the authorities or the departments as the person who was responsible for everything that was happening under the factory. Similarly, for gratuity, where there are any offenses under the Gratuity Payment Act, you could be punishable with, as a director, for imprisonment for a term of, you know, 6 months up to 2 years, and you know, the court has to be convinced that, you know, a lesser term of imprisonment or fine would actually end up meeting the ends of justice to the affected employees who did not receive such gratuity. Similarly, you have liabilities under the Employees Provident Fund and Miscellaneous Provisions Act. So wherever there is Provident Fund and you know, it's seen that the employer's contributions is not being made, or there are certain you know, provisions or consent has been provided to somehow avoid making these payments, or there's been neglect on the part of any officer of the company, such officer will be guilty of this offense and will be liable to be prosecuted against. Of course, the main acts under the Income Tax Act and the Goods and Services Acts, of course, if there are breaches in the duty of these directors, or there, you know, there's non-recovery of any tax due by them by the private company in any of the previous years, or GST has not been being paid by these officers, and it's proven that this officer of the company had knowingly, you know, they were told about this probably by the accountant, by the consultant, by the auditors, and they have still not acted to clear these dues or find a way to somehow correct their liabilities in this case, then they would be prosecuted against, and it might not just be monetary. You also face certain prosecutions under criminal liabilities. You have certain other kinds of liabilities which are under the Negotiable Instruments Act. In case of check bounces, it's basically considered to be a criminal liability. But during the Corona time, actually, this has been suspended. So if there is a check bounce, it's not considered at the moment as a default and with a criminal liability on it. You also have the Competition Act and the Insolvency and Bankruptcy Code. Both of these acts provide for how, what kind of liabilities can be imposed on KMPs and officers in default where they had known about certain rules or regulations. And of course, it's not obvious to always say that, ignorance, because you cannot say that you are entering into certain large transactions and that you have not taken legal or accounting or other advice where it had been specifically mentioned that you're falling under these acts. And therefore, if you don't do so and so regulations, you may contravene certain compliances, and this would actually amount to neglect on the part of any officer where you are entering into certain agreements and transactions and you haven't taken or solicited the advice of specified people for this reason. Under the Insolvency and Bankruptcy Code as well, it's important to note that if a director or a KMP has, made undervalued transactions, or they have knowingly defrauded the creditors, or have not done their due diligence while exercising while exercising different transactions or exercising their powers and capabilities and liabilities, where they are exercising their capabilities and all their powers in the business of the company and to do the best interests of the business of the company, then they can be prosecuted under the IBC. The IBC says that you have to provide, evidence to the fact that these directors and these KMP who are discharging the day-to-day affairs of the company, they had not foreseen the possibility of corporate insolvency for this company, and thereby resulted in so much of loss for their shareholders. And if it is seen that there was a clear, continuation of certain kinds of defaults by them, or, taking terrible decisions in terms of commercial decisions as well, they can be prosecuted under the IBC and they can be held personally liable. Their assets can be taken over and distributed to the even under the IBC as a way of payment, or the way of creditors seeking justice. And so now we come to how can we indemnify these liabilities of these directors and KMP. Of course, everybody has at this point probably realized that directors have huge responsibilities by being the key managerial personnel of these companies. And since they're responsible for so many decisions and so many compliances under so many different laws, it is difficult to say that there will never be a default. And it could just be a procedural default, but the procedural default may end up costing quite a lot. As a result of which, it's important to understand that, where the directors can be held liable, when there is a defaults in procedural or governance or corporate governance is one thing, and you can cover it with insurances or with indemnification agreements. But when there is a default under frauds, or where there are significant, defaults, like I was talking about the IBC earlier, these would not probably be enough, or these would not be covered by your insurances that these directors take. So when we're talking about different income tax laws, labor laws, environmental laws, then the liability of this officer in default is generally unlimited or limited up to the provisions of the Act. And these directors would obviously, of course, seek to protect their personal assets. There are certain safe harbor provisions, like I was mentioning, where if there is a proceeding for negligence or default or breach of duty, then the court has to determine case to case that the officer has acted honestly and reasonably, and that having regard to all these circumstances, that he ought to fairly be excused, and the court will relieve him either wholly or in part from his liability on such terms as it may think fit. The company may also provide certain indemnities to its directors. It might be provided in the constituent documents like your charter documents. It can also be provided within your employment agreements. Generally, directors enter into a separate indemnification agreement where the company says that they would make good on any kinds of losses which are occurring to directors during the performance of their duties. Indemnity agreements are just wide enough to cover any kind of complicated corporate transactions where it may be that commercial, there may be commercial reasons for losses or defaults of the director, but they would still exclude any kind of dishonest, fraudulent, or intentional kind of conduct. Indemnification agreements generally come with a director and officer insurance policy, which the company usually takes anyway if they are unable to financially pay for the indemnification later on. The D&O insurance provides indemnity to the directors and the officers of the concerned company against costs which are incurred in defending proceedings which are instituted against, and in respect of any damages which are awarded to the claimants against them, such as like in an out-of-court settlement. The premium which is paid on these insurances are not considered to be remuneration, but if that person is found to be guilty, then the premium paid on such insurance can be treated as part of the remuneration, thereby relieving some of the financial burden on the company. So it's important to understand that these insurances cover not just the directors, but also the company. And when there are procedural or larger defaults in compliances, it makes sense to have, especially where you're having transactions which are large in nature, or you've been in the company for a couple of years and you can see that the number of people and the compliances burden is just increasing. It makes sense to have a D&O insurance, which covers both your KMPs as well as your the company in general. All right, so the compliance management system that we're talking about today, it's more like a tool that we discuss. And of course, every company is a little different in how they manage the compliances of their company. As you can see on the slide right now, we have something called as the Company Sector Provisions or Act. And we've described some of the acts which are, which talk about compliances which are directly affecting the company, such as Companies Act, such as income tax, such as goods and service taxes, data protection regulations, and Shop and Establishment Act. And then you have certain provisions or acts which are with regard to your employees, where these have to be taken care of as well. So you're talking about your HR laws like maternity benefit and anti-sexual harassment, or you're talking about acts under the Contract Labor Act, the Bonus Act, Employee Provident Fund Act. All of these form employee-centric provisions and employee-centric acts. And all of these acts are, of course, having several large number of compliances. And as we were discussing, that these compliances are directly the responsibility of the KMP and the directors of the company. So the best way to sort of, and it's overwhelming to understand the nature and the number of different compliances and acts that have to be taken care of. So it's important to be able to have a certain system in place which takes care of this for you, so that if at any point of time you are accused, or the director is accused, or the company is accused that they have not done the due diligence, the fact that you have certain compliance management systems in place, whether it is for a smaller company and you're taking care of, in the way that you can, or if you're a larger company and you have the resources to make it into a kind of a tool to enact. And it can be like a tool which is available on the server for all your employees as well as for all your KMPs. Then, when it comes to a court of law, you can obviously show this as an evidence that you've taken care of as many provisions and as many acts and have done your due diligence on this part. So, as you can see, these are elements of a compliance management system. It's not complete. Oh, sorry. It's not complete because a compliance management system really depends on every company and how big your company is. It's not possible to probably have an entire tool, like I was saying, all set with all of these provisions. When you're a smaller company and you've just started out and you can't really spend this much on your compliance management system. But certain elements can always be available to your employees and within your company setup. So what you would probably have would be an HR or an employee manual, which talks about, all your different kinds of policies. It talks about your code of conduct, what is considered as ethical or non-ethical. It talks about the anti-sexual harassment policy, which is quite important these days because, not just because of the Me Too movement, but because we have in place what is the POSH Act, and there are very stringent liabilities in India regarding non-compliance of those. You have, certain compliances which you are required to take place, for corruption or bribery. You are obviously trying to keep at least a certain amount of IT security and data protection when it comes to your servers, or it comes to your documentation, it comes to your books of accounts, all which are there inside your company. Whereas you may not be able to implement everything that is there in elements of these compliance management system. You may not be able to have e-learnings or trainings of your employees, but once a year you may have a training where you talk about all these kinds of employee manuals, where you talk about corruption and bribery policies. You talk about what to do when, a whistleblower system would be what to do when there is a red flag or there is a breach, and who do you report it? How do you manage such a situation? You also would probably have a risk map, which talks about what you consider as a company and from a commercial standpoint, and also from compliance standpoint, which are the most important commercial, tax, and financial risks that you see for your company in the next, in the next couple of years. And you map that out, and you have that with you, and you have to take a periodic check on whether or not you are complying or you are providing for a good framework that takes care of certain compliances. So like I said, the CMS system is very different for each company, and every company has various different kinds, or certain parts of the CMS is already available. I'm sure that you already have that in your employment agreements for your employees. It's possible that you have a code of conduct which is always provided from say your parent or shareholding company. And all of these kind of different commercial contracts, the validity, etc., these are taken care of within the contracts itself. But the idea is to make sure that it is relevant and that it is continued, always, that the processes are always there, and that you are assessing and identifying, prioritizing the accountability of all of these different kinds of threats that you see in your CMS. You have to conduct awareness and training programs, and you have to periodically repeat such risk assessments and document and compliance updations to make sure that whatever you're doing for your CMS so far, it is relevant. Wherever required, please take external inputs by way of lawyers, by way of consultants, etc. It's also important, not that I'm just saying that for Rödl Partner, but I'm just saying that when you take the external inputs, it's also seen that you are taking responsibility for your company's decisions, and you are considering the compliance requirements and the risk requirements to be adequate and important enough that this is, that this is being covered. And it's also important, of course, that if you have a breach, if there is a red flag, if there is a risk, a high risk that something has been found, and it's that you don't exactly know how to take care of it, that there is a system in place of how to treat or how to go about treating such breaches or red flags. And so you can contact us for any questions that you may have with regard to compliances, with regard to how to put up your compliance management system, and if you have any other questions as well. I know I've definitely exceeded the time a little bit here, but we do have some more time, I think, where we can take questions for about 5 minutes. If there are any questions. Okay, so I can't actually see that there are any questions in the chat box. I will wait for another 1 or 2 minutes. In case you want to really ask these questions later on, you can contact us on our email IDs, which are given here, and even on the email IDs that you might have found on the registration. You'll also get a copy of this presentation, so please feel free to ask us questions over there as well. I'm going to wait for another couple of minutes. I hope I didn't scare everybody with the amount of different kind of compliances there are on the directors. Okay, I don't see any questions coming in. So, like I said, please feel free to write to us. Thank you, everyone. It has been a pleasure having you as an audience today. Please attend our other topics on the Digital IT webinar series. And, there are several interesting topics coming up, so it would be great that you attend them. And we hope everyone remains safe and healthy during this period. Thank you, everybody. Okay, bye-bye.